Hi, I'm Ramin Asgard. I'm an immigration attorney and former consular officer and U.S. Foreign Service officer with the U.S. Department of State. Uh, I wanted to do this video with Lawfully because I've been with Lawfully from the beginning, and I'm very proud of what they've accomplished in making the immigration process for so many people accessible and allowing them to get access to uh, quality information affordably and conveniently. And so I try to do that in my own practice, and I really support what Lawfully is doing for immigration. So I'm here to answer some questions that we've gotten from uh, folks, lawfully customers, and get right to it. So the first question is, how do you expedite a K-1 visa, which is a fiance visa? And expedite requests in general go through a couple different steps. Obviously, it's best if you request the expedite uh, at the beginning of the process when you first file. USCIS has said that they look at each expedite request on a case-by-case basis. And there's a couple different things that they look at on whether or not to expedite your case. And I'll just quickly list them. Severe financial loss to a company or a person, emergencies and urgent humanitarian reasons, U.S. government interests, things that affect and benefit the U.S. government, and then clear error by USCIS. Um, a couple other things that they add are if there's an aging out child beneficiary, and if someone is the beneficiary is going to be giving birth real soon. Those are other things that can sometimes get a case expedited. On a fiance visa case, it really depends on what stage of the process it's at. So it's a little hard to answer it in general, but those are the overall expedite rules and how they will decide on the expedite. Next question is, I had my I-130 approval since December, and still till now, I've not received anything. Well, I would say of the inquiries that I get and of the questions I saw from the whole list, processing delays and long waits are some of the most common things that people ask about. And processing delays have been caused by a number of things. And I think, folks are a little bit familiar with them, but I'll just quickly go over what's going on. And there was obviously a big delay in 2020 with COVID, where the USCIS shut down for about 4 months, and the embassies and consulates overseas shut down for a year for immigrant visas and still haven't fully resumed operations in most cases. So that's created a huge backlog, and that backlog is affecting applications across the board. And if you look at this graph, you'll see that they've risen steadily every year since 2017 till now. So unfortunately, the I-130 approval that you're waiting for, that's just a backlog situation in most cases. And are there things you can do about it? Yes, there are things you can do about it, and we can get into those a little bit later. The next question is, can we use UberLyft income for immigration purposes if we claim that income in our taxes? I'm assuming that would be using it as supporting income for an affidavit of support. And the answer is yes, you can use UberLyft or that kind of side work income. That is considered self-employment. And so with self-employment, not only do you have to submit the tax transcript or the tax return, they prefer the tax transcript, but they also, it's beneficial if you submit several months of your bank statements just to show the course of the income coming in. Question 4 is, does the wait time differ based on the home country of the beneficiary? I'm assuming you mean This question means the wait time for an immigrant visa process with an I-130 file to be finished and the person to get their interview for their immigrant visa overseas. Now, in my foreign service life, in my consular officer life, I was an immigrant visa chief, and I, as I have noted, interviewed many people for these visas. Now, the delays that people are seeing now vary from country to country a bit, based on what kind of staffing levels they have, what kind of volume they have, and so on. So it really does vary from country to country. There are countries where things get delayed a really long time just at the National Visa Center before anything gets sent out to embassies, because the embassy is telling them, we just can't take any more cases right now. And so the National Visa Center can't send it to the embassy unless the embassy can absorb the cases. So it does vary from country to country. All right, next question is, I submitted my Form I-485 in February, and after a successful interview, what I believe was a successful interview in March 2021, it's been quite a while, a total of 2 years, since I have not gotten a response. Any advice? Well, that's one of the delay situations where you've had an interview and then it's taking many months to get any result. Now, that case is with a USCIS field office, not one of the service centers. And so the appropriate place to send any inquiries would be a field office. Now, I don't know about the specifics of this case, and it can vary for a lot of reasons why a case can get delayed after an interview. And it really would depend on the dynamics of the interview and the dynamics of the case. But in general, whatever types of solutions you try to go for, you should focus on the USCIS field office for providing, for making an inquiry. Next question is, I'm married to a U.S. citizen and I'm South African. I'm starting the process of applying for a green card, but I don't have an unabridged birth certificate. Well, this is an easy one. I have a client or someone who did a consult with me who specifically was denied, not just our request for evidence, denied because they didn't have a long form birth certificate from South Africa. So if it takes a little bit of extra time, it's worth it, because the birth certificate on that case is a primary document. If you're missing a primary document at the beginning, they may go ahead and ask you for an RFE, yes, but the time is probably better spent getting the primary document and filing the application with that primary document, if at all possible. And if you can't get it for whatever reason, there's a possibility of an overall case denial, which is certainly something you don't want. So you should make every effort to get it. Is it possible to expedite an I-45 related to an employment-based adjustment of status? Now, this isn't a family situation. This is employment. The answer is yes, it is. And basically for the same reasons now that we talked about with the expedite request previously. There are a couple wrinkles there. Obviously, severe financial loss will be a much bigger factor in that expedite request, because you're talking about severe financial loss to a company if your I-45 is not processed on an employment-based application. The other thing is the application cannot be one that has premium processing. If that's the case, you can't request an expedite. But other than that, the overall general, yes, you can request an expedite on a employment-based I-45. The next question: can a person get a non-immigrant visa like a B1, B2, or an F1 visa when there is a green card in process? In other words, somebody's applied for you, petitioned for you for an immigrant visa, and you wanted to know, this person is asking, can I apply for a tourist visa or a student visa while that's pending? Well, of course, that depends on a couple things. If the immigrant visa petition is one that is immediately or very soon available, or it's one that's a preference category where it's many years until it's available. But in general, you can apply for and have a reasonable degree of success with a tourist visa or a student visa both called non-immigrant visas, while you have an immigrant case pending, if you can still show substantial ties to your home country at the time. Just by itself, having an immigrant visa petition pending is not enough to rule out getting a non-immigrant visa. Now, on the DS-160, the non-immigrant visa application, there's a specific question: has anyone filed an immigrant visa petition on your behalf? And the key is you have to answer yes there. You can't answer no, because that by itself is enough to deny your non-immigrant visa application because you didn't disclose that. But if you do, and then you have a very specific and documented reason for needing to go to the United States, whether for tourism or otherwise, it is possible to go ahead and get a non-immigrant visa. The next question. My green card expired 2 years ago, and I need to travel. The renewal is in process. Can I get a stamp in my passport to travel if I schedule an InfoPass? The short answer is yes, you can. If you can schedule an InfoPass with USCIS through the customer service line at one of your, at the local field office, USCIS field office, you can go get an I-551 stamp in your passport, which is equivalent to having a green card, and documents that you're a permanent resident. And I would strongly recommend that you do that if you plan to travel and you have an expired green card. You could take your chances, but it's really not worth it. It's much better to have that stamp in your passport. And the last question. We have gotten our date for the first interview, but my EAD, my employment authorization document, has not come yet. When will it come? Well, this issue of EADs being so delayed, again, we talked a little bit about delays before, but EADs in particular being so delayed that they're costing people jobs, they're really hurting companies who have immigrant employees, has become a crisis level issue. I mean, right now, EADs are routinely taking up to a year. They were previously taking about 3 months. So this growth in the time that EADs take, which you can see on this chart as to how much time EADs are now taking, has really affected a lot of people. There have been multiple lawsuits, class action lawsuits by affected people trying to get USCIS to do a better job in adjudicating EADs quickly. One of these lawsuits has already resulted in a change to the EAD rules for certain categories of visa holders, H4, E2, and L2, I'm sorry, and E2. Spouses have had their EAD renewals made automatic. And there have been other positive steps to try to address this EAD backlog. But the issue with this form of delay and other forms of delay is that, unfortunately, the reform measures that have been suggested to try to fix this are all fairly long-term. And about the only way to get quick action on any of these, beyond doing, a congressional request or asking an attorney to follow up, are the lawsuit known as a writ of mandamus. And these have become far more common than they ever were before because of these processing delays. And so if your case, whether it be an EAD or other type of delay, has been substantial and is causing hardship, you can file litigation known as writ of mandamus. And what a writ of mandamus does is it is an order from a federal court to compel the government, in this case it would be USCIS in most situations, to take action on a matter before them, not necessarily to approve, but to take action pretty much immediately, which they generally have to do within 60 days. So it's a bit of a last resort because it's federal litigation, but it is one way to get the measure done. Now, the good news is there are a lot of these writs of mandamus out there being done as class actions. And so chances are, if you're someone who's facing a delay, there's an ongoing case which is trying to correct this, and you would benefit if the class members win. All similarly affected people gain the benefit. So it's not an easy thing to resolve, but these delays are at least something on the radar of the folks who care about these types of issues a great deal, and they're doing everything they can for it. If you're facing these types of delays, this is a matter that we do address. So I'd like to thank you all for listening in on this Q&A session, and I want to remind you all that, like I said, these many factors went into USCIS delays and U.S. Embassy and consulate delays, and COVID-19 delays are affecting everywhere, not just in immigration, but everywhere. And I know that a lot of you sent questions in, and I really respect that and your interest and passion about the subject that you care about and your cases. So even though I couldn't get to all of the questions, please feel free to get in touch, and I'll be happy to follow up with any of you regarding the questions you submitted. Thanks very much. This was Ramin Asgard of Asgard Law Offices doing this Q&A for Lawfully. Thanks very much for listening. Bye-bye.